Okay, hi everyone. Hope I'm audible to you. Today we'll be discussing intellectual property litigation. So the need to address this topic specifically arises because, of course, there are litigations and disputes of all kinds, uh, which are continuously being dealt with by courts. But intellectual property litigation becomes a little technical and a little specific, requiring to some extent subject matter knowledge. So today we'll be discussing some aspects of general litigation, which are also applicable to intellectual property, and some specific um, aspects of intellectual property litigation which wouldn't otherwise come up or apply as well. So I've divided today's lecture into three parts. So the first part, we will be talking about the basics of in relation to intellectual property, who can sue, who can be sued, and for what purposes a suit can be filed. In the second part, we will delve into the specifics of jurisdiction and what kinds of courts and tribunals have jurisdiction over intellectual property disputes. And in the third part, we will be discussing how a plaint is drafted in an intellectual property suit, what kind of defenses, both on preliminary issues and on merits, can be taken up in intellectual property disputes, and some civil remedies that are available to an intellectual property owner who files a civil suit for infringement. So, first, there is a concept in law called locus standi, which is basically Latin for legal standing. Legal standing is required to initiate any kind of legal action whereby a person who has gone knocking on the doors of a court is legally and mandatorily required to explain what his standing is in relation to the dispute and what entitles him to sue. So we will be discussing locus standi in relation to intellectual property. So the most obvious thing in relation to intellectual property is that a person who is the owner of the actual intellectual property has the ability to sue. So let's get into a few examples, right? So the first kind of right to sue arises in relation to copyright, arises in favor of the owner of the copyright. So the owner of a literary work or an artistic work or a musical work, being anybody, being the composer or the writer or the publisher, as the case may be, whoever is the legal holder of the rights in the intellectual property will be entitled to sue. Now, interestingly, unlike in real property, all bodies of intellectual property law, including Copyright Act, Patents Act, and Trademarks Act, cover the aspect of a co-owner, meaning two people have undivided and inseparable interest in intellectual property. So this is a concept covered in various types of intellectual property laws. So what happens when there are two co-owners is, for example, the Patents Act doesn't allow one co-owner to sue in respect of infringement or even his undivided interest in the intellectual property without the consent of the other owner. So one joint author of copyright cannot deal in the copyright without the consent and approval of the other joint author or owner of copyright. So in terms of locus standi, when you are in a position of initiating legal action, you have to first think about who is entitled to initiate the action and whether there are any co-owners involved, right? So I'll give you an example of where this becomes relevant. So in the case of a film, for example, according to Section 2 UU of the Copyright Act, the producer is the owner of the film, right? But the producer may not have the rights in the script that may still belong to a writer. More so, the producer may not have specific rights in the characters involved in the film. So first you look at the kind of infringement that has occurred, right? So let's say it's the creation of another movie based on the same characters, right? But not a copy of the movie itself. In that case, whose rights are you really infringing? Are you infringing the rights of the producer of the original film, or the producer of the writer of the script of the original film, or or the writer of the original script that gave rise or gave birth to the characters whose infringement we are discussing? Right, so these are the cases in which it becomes relevant, in that a suit is maintainable only if the correct person sues or initiates the legal proceeding. Now, another anomaly that is applicable only in intellectual property is that an exclusive licensee of intellectual property is also entitled to file a suit. In fact, when discussing uh, ownership vis-a-vis infringement, the Copyright Act specifically says that owner of a copyright would also include an exclusive licensee. So an exclusive license usually is a license given to a third party, even to the exclusion of the original owner. So because the exclusive licensee is now the only person who is validly using the intellectual property, the exclusive licensee has been given the same status as that of an owner. The other two concepts which are otherwise also there in law in respect of rights in relation to other, real property and actionable claim are equitable ownership and representative action. So equitable ownership arises in a case where, let me read out of, this is Lionel Bentley and Brad Sherman's commentary on intellectual property. It's one of the recommended readings that I've given in my list for this course. Yeah, so they say that usually it is the rights holders as defined in the relevant legislation who are able to bring an action for infringement. In certain situations, however, other parties are able to litigate to protect their interests. For example, in some cases, equitable owners are able to bring an action where their intellectual property rights have been breached or infringed. To do so, they must join the legal owner before final judgment can be given. So let's say there is an exclusive franchisee of a trademark, right? An exclusive franchisee of a trademark in India who does not have presence in India. Now, for the franchisee to be able to protect the integrity of his brand, he should be able to sue. So in equity, he has some rights in law, although he is not an owner. Now, while in English law, it's possible for an equitable owner to bring the suit by itself, in India, it's not possible. So the equitable owner has, in some cases, been able to bring legal action with the help of the original owner, both bringing the legal action together at the same time. The last kind of representative right to sue that occurs in intellectual property law is the right to bring representative action. So representative action can be brought when a person files a suit in a representative capacity for a class of persons. So for example, the Copyright Act, we have copyright societies that are formed, which act in a representative capacity for all owners of certain types of copyrights. So we have, for example, PPL, which is the phonographic performance, the phonographic performers phonographic performers society, a copyright society, which represents the interests of people who have rights in sound recordings and producers of sound recordings, that is. And these owners have all basically given transferred to PPL the right to represent them in various capacities. So sometimes these copyright societies are able to bring representative action on behalf of the owners of the copyright. So while exclusive licensees are usually able to bring an action for infringement, um, uh, for passing off, for instance, which is a right that arises under common law, it's not possible because it's a statutorily created right to bring legal action. And in some cases, courts have allowed representative actions to be brought, notably through trade associations, including through the British phonographic um, industry. Now, PPL, IPRS, and other rights owners such as Simca have been bringing legal actions on behalf of their owners in different types of situations, but directly for infringement, to see an action brought by a person in representative capacity is rare. But in cases that involve collective bargaining, or where the license that is held by PPL, IPRS, or Simca is itself in question, then these litigations have been brought, although in a representative capacity. Now, this is from the side of infringement, right? So where there is an offense occurring of infringement, there is an infringer and a person being harmed by the infringement, who is the owner of the intellectual property. So now what I just explained all this while applies to the right to sue from the side of the owner. Now, there is an other side to this as well, where a person who fears being alleged of copyright or patent or trademark infringement can bring certain actions before the court. So the first is under the Patents Act, under Section 105, there is a specific right available with a person to bring an action for obtaining a declaration of non-infringement. So non-infringement is covered under Section 105 of the Patents Act, which basically says that any person may institute a suit for a declaration that the use by him of any process, or the making, use, or sale of any article by him does not or would not constitute an infringement of a claim of a patent against the patentee or the holder of an exclusive license under the patent, right? If it is shown that the plaintiff applied in writing to the patentee for an exclusive license, or asked for a declaration that the effect of the declaration claimed and has that the plaintiff has applied in writing to the patentee or the exclusive licensee for a written acknowledgement to the effect of the declaration claimed and has furnished him with full particulars in writing of the process or article in question, and that the patentee or licensee has refused or neglected to give such acknowledgement. So where such an acknowledgement is sought from the patentee or the exclusive licensee, and such acknowledgement is not given, and this is successfully established, then a declaration specifically of non-infringement can be obtained under the Patents Act. So this is being filed by somebody who is alleged or may be alleged to be committing infringement, and not the person who's complaining of any infringement operating against him. So the other kinds of suits that are normally filed in courts in India, which have become now regular, is a declaration of groundless threat, right? So under the Copyright Act, this concept is covered under Section 60. To give you the right picture of what exactly it applies to, I want to read from the section and then explain its applicability. Section 60 basically says that where any person claiming to be the owner of a copyright in any work by circulars, advertisements, or otherwise threatens any other person with any legal proceedings or liability, with any person with legal proceedings or liability in respect of alleged infringement, may institute a declaratory suit that the alleged infringement to which the threats relate was not in fact infringement, and can obtain an injunction against that person from issuance of such threats, and recover even damages for this purpose. So the thing that mainly applies here is that if the person making the threats with due diligence commences and prosecutes the alleged infringement and files a suit, then the claim for groundless threat goes away. The suit becomes infructuous. So basically, groundless threat is a situation that is groundless threat as a provision was brought in to cover a situation where larger companies were always sending incessant threats and legal notices and publishing advertisements and basically putting it out there in the public that a mark was infringing their mark, but never brought any legal action against these smaller players. So this basically amounts to harassment, because you're continuously issuing notices, you're continuously alleging infringement, but you're not doing anything about it. So as a policy decision, various jurisdictions brought in a law to govern groundless threats, wherein if you feel you are receiving groundless threats, you can initiate a suit, wherein you can seek a declaration that whatever the notices are being issued to you are threats that are groundless or baseless, and recover damages in this regard. But this claim obviously goes away if the person alleging infringement is diligent enough to actually prosecute the alleged infringement and file a suit and follow through. Right. So now we have looked at who can sue in the case of an intellectual property violation, both from the perspective of the person complaining of the infringement and a person who might be alleged as the potential infringer. Next, we come to the concept of who can be sued. So locus standi generally even covers the concept of a suit or a legal action being maintainable against the person against whom it is actually brought. So in all of intellectual property, there are mainly two types of infringement that is covered. One is primary infringement, and the second is secondary infringement. Primary infringement, as the name would suggest, is basically the actual act of infringement itself, which is the copying itself, which is the primary infringement. So the act of publication of illicit copies of books, or the act of making of illicit copies of movies or digital copies of movies which are unauthorized copies and not permitted by the owner, would very specifically amount to primary infringement. Secondary infringement is a situation that covers everything else. So infringement is not always a simple action. There are always other third parties involved in the act of infringement who either by tacit approval or otherwise are involved in the infringing action, but are not primarily the infringers themselves. So both these categories of persons can be sued under intellectual property law. Right? So I'll just get into some parts of secondary infringement, which will be useful to sort of understand how IP litigation really works. So one is, other than the person who is actually manufacturing the goods that are being sold in the market, how do I explain this? Okay, so let's take a product in the market that is counterfeit, right? So every counterfeit product obviously has a manufacturer, a seller, and a person who is using the product for the actual activity of counterfeiting. So how counterfeiting sometimes works is the manufacturer manufactures the product, but somebody else is actually slapping a third party mark unauthorizedly on the product and then selling it. So the manufacturer, the person actually engaging in counterfeiting, and the person selling the product are all different parties. Now, while the person actually engaged in the counterfeiting is the second person that I just mentioned in the chain of events, the manufacturer and the seller may also by tacit approval be part of this activity. They might know. And if it is possible to prove in court that they know, an action of infringement can even be brought against them. The second concept is of vicarious liability. So basically, this is a case in which there was a concert performance, and the person who was handling the production and operating the concert basically knew that the pieces that were going to be performed would be in violation of the public performer's rights of the actual author slash owner of the pieces of music. So by vicarious liability, those people were held liable. So as the term would suggest, vicarious liability is generally a concept in tort law, which suggests that an employer or a person under the approval and approval of whom something is happening should be held vicariously liable for the actual damage or loss that occurs, right? So in a situation where let us say I am a taxi driver and I work for ABC taxi company, right? Now, while driving a car, I get into an accident because of my own negligence. Now, I am only an employee of the ABC taxi company. And as an employee, of course, I'm liable for my own actions, but also because the accident occurred during my course of employment, my employer is also liable by way of vicarious liability, because he is liable for all my actions, because none of this would have happened outside of my relationship with my employer, which is the employer-employee relationship, right? So that's how vicarious liability arises, and vicarious liability is also applicable in cases of intellectual property infringement. Then there is a concept in common law and English law of being a joint tortfeasor. Basically, a person who commits a tort or an offense is a tortfeasor, and a person who commits that tort jointly with other people, they all become joint tortfeasors, right? So there are two concepts here of conspiracy or inducement or common design. So basically, Lord Mustill, in the judgment of Unilever versus Gillette, explained this concept of how someone can be a joint tortfeasor by common design. He says that I use the words common design because they are readily to hand, but there are other expressions in cases such as concerted action or agreed on common action, which will serve just as well. The words are not to be construed as if they formed part of a statute. They all convey the same idea, however. This idea does not, as it seems to me, call for any finding that the secondary party has explicitly mapped out a plan with the primary offender. The tacit agreement will be sufficient. Nor, as it seems to me, is there any need for a common design to infringe. It is enough if the parties combine to secure the doing of the acts which in the event prove to be infringements. So basically what happened was, in this judgment came in a context where one of the parties to the suit was trying to implead both the subsidiary company and the parent company, complaining of patent infringement and other kinds of intellectual property infringements relating to the combination of a drug used as an antidepressant. So what happened in this case was, they tried to, after initiating the suit, they later tried to bring the parent company into the picture, saying that without the parent company, the act of infringement would not have occurred at all. And in that context, the court went on to note that when we say common design, we don't expect two or three people to come and have consensus and meeting of minds, basically, to actually commit infringement and then go ahead and commit infringement. That's not the standard of law that applies. So the basic standard of proof that applies is where two or three people come together and do certain things or commit certain acts which would together form a cause of action for infringement. That is enough to establish that somebody is a joint tortfeasor or is engaged in what we call secondary infringement in respect of intellectual property law. Okay, so now I'm going to get into a little bit of what courts have jurisdiction over intellectual property disputes, and how this jurisdiction really comes about. I'll be looking at some aspects of jurisdiction, which, I mean, some tribunals which don't exist today, but we have to look at it because right now courts are dealing with transfer of matters from these non-existent fora as well. So the first most obvious forum is civil courts, commercial courts, and high courts. So basically, the civil courts, commercial courts, and high courts have jurisdiction to deal with intellectual property disputes, and disputes generally pertain to infringement, invalidity, and groundless threat. Other than this, there are other disputes that arise under the Act, for instance, under Patents Act, there's a process of revocation of patent. There's a process of rectifying the register in the trademarks register, and other disputes under the Copyright Act relating to licensing and other things. These were under the erstwhile Copyright Board and the Appellate Board, Intellectual Property Appellate Board. But these, in 2021, by way of a notification, these fora were removed. And now high courts are given jurisdiction. The high courts of each state are given jurisdiction with respect to these aspects as well, right? So if you look at section 117 of the Patents Act, 117A. So appeals used to be covered from section 116 to 117H before. And the Intellectual Property Appellate Board had a wide range of powers in this respect. But now, basically, the Act says that no appeal shall lie from any decision, order, or direction made or issued under this Act by the central government or from any act or order of the controller for the purpose of giving effect to any such decision, order, or direction. An appeal shall lie to the High Court from any decision, order, or direction of the controller or the central government under section 15, 16, 17, 18, 19, 20, 25, 28, 51, 54, 57, 60, 61, 63, 66, 69, 78, 84, 85, 88, 91, 92, and 94 of the Act. So these are various powers that are given to the Controller General of patents and other authorities under the Act. So any appeal from these decisions will come directly to the High Court now, since the Intellectual Property Appellate Board doesn't exist. So I'm just going to do a few of these sections in detail so that you understand the nature of what is happening here. So, for instance, Section 63 speaks about surrender of patents. So, a patentee may at any time, by giving notice in prescribed form, may surrender its patent, right? And any decision in relation to this is taken by the controller, even including oppositions in this regard. And any such decision can be challenged by way of an appeal. Now, this appeal gets filed before the High Court. That is an example of what I was trying to explain. Okay. So, okay, similarly, rectification. So basically, an application can be filed before the controller of trademarks for rectifying the trademark registry in the event that a registered trademark is not being used or is not being used in accordance with the conditions or in accordance with the law, or in accordance with the conditions associated with its registration. So these rectification petitions were before maintainable only before the registrar or the Intellectual Property Appellate Board. Now these rectification proceedings can also be initiated before the High Court with jurisdiction. Now, when I say jurisdiction, jurisdiction is a concept that is covered under various laws that are applicable to intellectual property disputes as well. So, jurisdiction is basically the ability, the legal ability of a court to take up a particular dispute. So, jurisdiction is of three kinds. One is subject matter, two is pecuniary, and three is territorial, right? So, territorial jurisdiction means there are several courts in the country, right? So each court has its own territory that it takes care of. And then there are courts above that court which have superintendence over the lower courts. And this level of hierarchy goes up to the Supreme Court. So starting with the Supreme Court right at the top, each high court of every state has jurisdiction, territorial jurisdiction over matters occurring within that state, right? And beyond that, every district has a court at the district level which has jurisdiction over what is drawn as a boundary of that district. And in that district, there are lower levels of courts as well, depending on which district you are in. So first step when you go to the court is you have to first ensure that you are before a court that actually has territorial jurisdiction over your dispute. Territorial jurisdiction, right? So the foundational principles of how to determine whether a court has territorial jurisdiction arises from section 20 of the Civil Procedure Code. So basically what the code says is a dispute can be brought in a place where one of the defendants, where the defendant resides or carries on business, or one of the several defendants resides or carries on business, or where the cause of action arose or a part of the cause of action arose. So let me break this down for you, right? So if I have to sue, let's say let's say I'm filing a suit in respect of recovery of money, right? Let's say Mr. A owes me 20,000 rupees and I have to file a suit in court. Which court do I go to? I either have to go to a court where A resides or carries on business, right? Now, if A, B, and C owe me money, I can go to a court where either A or B or C reside or carry on business. I'm obviously oversimplifying this. This is way more complex and there's a lot more law involved in this. But for our purposes, understanding this much is sufficient for now, right? And the third thing is a concept called as cause of action. In very simple words, cause of action basically refers to a bundle of facts that become the reason for you to come to court. So basically, if I am complaining of an injury, if I am complaining that that some rights of mine have been violated, which is the reason for me to knock on the doors of a court, I have to explain what facts actually form part of the cause that have led me to come to this court, right? So that is called cause of action. So another way to determine whether a court has territorial jurisdiction or not is I can go to a court where the cause of action either arose fully or partly. Now, other than these three principles, there is an anomaly in intellectual property law where, for example, it's on the slide, section 62 and section 134 of the Trademarks Act allow the owner of the trademark or the copyright or the person suing, as the case may be, to file the suit where they reside or carry on business. So this is very different from how CPC otherwise applies, because you don't allow a person to file a suit where they reside or carry on business. They have to go to the jurisdiction of the defendant whom they are trying to pursue, right? But only in the cases of intellectual property, for the sake of convenience, we allow the plaintiff to sue where he resides or carries on business. Now, further to this, there is another added criteria under the Patents Act and the Designs Act. The Patents Act basically says, and the Designs Act as well, in section 22 and section 104 respectively, basically say that if I have a claim of infringement against you, one of the grounds that you can claim against me to say that there is no infringement of patent is that my patent is invalid to begin with. So I raise a question of infringement before the court, and you counter my dispute of infringement by raising a question of invalidity as to the patent, right? So when there are grounds of invalidity raised and the question of revoking the patent itself comes up, then the case automatically gets transferred from the city civil court of the or the district court having original jurisdiction over the matter to the high court. Okay. So generally what you remember is you sue where the defendant resides or carries on business, or where one of the defendants is, or where the cause of action fully or partly arose. In addition to that, you can, in the cases of intellectual property, sue where the plaintiff resides or carries on business. Further, where a suit is already filed, if you are the defendant, you can bring up an issue of invalidity. And if an issue on this point is framed, you can have that suit transferred to the jurisdictional high court of the state, right? This covers territorial jurisdiction. This just tells you which place to sue in. Now, another type of jurisdiction is pecuniary jurisdiction. Pecuniary jurisdiction depends on the value of the relief that you are seeking. So, we'll cover the reliefs in a bit. Basically, each relief in a lawsuit is valued at a certain amount. So, based on the value, you will decide on which court to go to. So, for instance, at the district level in, let's say, Hyderabad, which is where I practice, there is a chief judge and additional chief judges at the top level, and below them are the senior civil judges, and below them are the junior civil judges. So a junior civil judge will deal with a dispute that is valued up to 20 lakhs. Between 20 lakhs and 50 lakhs, you would have to go to the senior civil judge, and above 50 lakhs, you would have to go to the district judge. So, if your intellectual property suit is valued at, let's say, 1 crore, then what happens is you go to the uh, chief judges category to file the suit. I'm just going to pause here for a moment. Right. So that gives rise to the question of pecuniary jurisdiction. Now there is the other matter of the Commercial Courts Act, which sort of covers the aspect of subject matter jurisdiction. So based on the subject matter of the suit also, um, in other words, the subject matter of the suit also plays a role in deciding where you can actually file a lawsuit, right? So in India, we have something called the Commercial Courts Act, which basically categorizes some disputes as commercial disputes. Intellectual property disputes are also characterized as commercial disputes. Now, in some states, the base value for a commercial dispute is at 3 lakhs at the moment. And in some states, like in Telangana, the base value for a commercial suit is at 1 crore, right? When I say base value, this is defined as specified value under the Commercial Courts Act. So if there is a suit of value above this 3 lakhs or 1 crore, depending on which state you are in, and it is an intellectual property dispute, such a suit would have to go to the commercial court for resolution, right? So basically, if there is a suit, it pertains to intellectual property, and over and above that, it meets the criteria of specified value, you can only go to the commercial court of that relevant district to file this particular suit. In each state, typically there is only one commercial court, in the sense one district where there is a commercial court. For example, there are about 6 or 7 commercial courts in Bangalore district dealing with commercial disputes arising all over Karnataka. Similarly, in Telangana, we have commercial courts in Hyderabad and Rangareddy districts dealing with commercial disputes from all over the state. So, similarly, all states have their own commercial courts. And there is a commercial division also supposed to be constituted at the High Court level, which is also competent to take up intellectual property disputes. Now, beyond this, if I get into this topic, it gets too technical. So I've just tried to touch upon it to sort of give you a sense of how jurisdiction works. But otherwise, this is mostly useful for a practicing lawyer, and largely is learned, on the job. But I think for the purpose of this class, I think this is sufficient. Okay. Now, preparing to file a suit, right? So, as a person who is preparing to file a suit, who is either going to complain of infringement or groundless threat or any of these things, the first step you ought to take is to issue what we call a cease and desist notice. Okay. A cease and desist notice is basically a notice to a person saying, hey, look, I am the owner of X intellectual property. It is my exclusive right to do all of these things. And you, by making either an unauthorized publication or unauthorized use of my trademark or whatever it is that you are complaining of, are violating my exclusive intellectual property rights. So I hereby call upon you to cease and desist from doing this, right? We call it a cease and desist notice. Now, despite that, if the person does not comply and continues to infringe upon this intellectual property, then you can file a lawsuit. Now, prior to filing a lawsuit, I said we are categorizing this now in India as a commercial dispute, right? So, in the Commercial Disputes Act, there is a mandatory requirement of what we call pre-litigation or pre-institution mediation. So, you would have probably been exposed to this in other classes where um, other than going to courts, there are a class of remedies available which we call as alternate dispute resolution mechanisms, which is basically trying to resolve your dispute outside of the court of law. In this, there are different categories such as arbitration, conciliation, and mediation. But mediation is one such concept where there is a mediator who tries to mediate between you and the other party, between the parties, and tries to come to an amicable resolution that is agreeable to both parties. Once the parties agree and they sign the mediation settlement or order, they are bound by this settlement, right? Now, this entire process happens by consent. Now, what the court has done is to allow for easy and quick resolution of commercial disputes. They have because suits remain pending for a very long time in India. They have made this pre-institution mediation compulsory. So basically, if you're filing an intellectual property dispute, what also happens is you have to go through this process of pre-institution mediation, which is mandatory. Unless you're able to show that urgent reliefs are required and you don't have the time or the bandwidth to actually go through the mediation process. But because the Supreme Court has also on multiple occasions held that this mediation is compulsory, you have to have a good reason and a good sense of urgency to show the court that this is a step worth skipping in your case, right? Otherwise, when you're drafting a plaint, especially in an intellectual property dispute, you need to keep four things in mind, right? Apart from your merits, wherein you establish the facts or the fact pattern that led to the infringement itself, four things have to be done very precisely and very correctly while filing a suit, right? The first is cause of action. First, you have to establish what is the cause of action. I already explained to you what cause of action is that led to the filing of the suit. Second, always ensure you are filing the suit in the correct jurisdiction. Otherwise, this becomes a ground for return of plaint under Order 7, Rule 10 of the CPC, which means the suit is not maintainable before the court that you approached. Then you have to also advise your client on what we call limitation. So basically, in every case under the Limitation Act, the law prescribes a particular time limit within which you ought to have approached the court, without which the suit is not maintainable, right? So a period, basically, if you owe me a debt of 20,000 rupees, it can't be that for as long as I am alive and my children are alive and my grandchildren are alive, the right to sue you for that money accrues, right? So the law says that from the time the debt has become due, I have 3 years within which I have to file a case. If I don't file the case within those 3 years, I'll completely lose the right to file a case at all. So this law of limitation applies to intellectual property as well, right? So you have to ensure that your litigation is being commenced within what we call limitation period. And the last one is valuation. So you have to value the suit properly and bring it before the correct court. I'll speak about valuation of reliefs next. So these are all the remedies that are available in an intellectual property dispute, right? So first is injunction. Injunction in law basically means an order of court by which you are prevented from doing something. It's an order in the negative. Injunction can be of three kinds: temporary, permanent, and mandatory injunction. So temporary injunction is where you get an order of temporary injunction during the pendency of a case. So while the case is still pending, so that your rights are not eroded while the case is still pending final adjudication. If you establish a prima facie case before the court, if you show that you have a prima facie case, the balance of convenience is in your favor, and irreparable hardship will be caused to you if an injunction is not ordered in your favor, the court can grant you a temporary injunction while the dispute is still pending. The next one is permanent injunction. So the same relief becomes permanent if it is decreed at the end of the suit, right? Mandatory injunction as opposed to a permanent injunction is, instead of preventing you from doing something, it's a directory order, it directs you to do something, it's in the positive. Okay. And Anton Pillar orders are basically orders by which the court can allow you to, in the presence of an advocate commissioner, maybe go and inspect a particular premises and seize goods. This is done to basically protect the intellectual property. Mariva injunctions and John Doe reliefs were already covered by Mr. Ashok GV in the previous lecture, so you can refer back to those notes and those lectures. I don't want to overlap with things that have already been covered. Okay. And then there is accounts for and profit. So basically, in a case of intellectual property, what happens is, by unauthorized use of somebody else's intellectual property, you are making money, right? The infringer is making money. So other than giving you compensation, which we call as damages in this case, which is the previous item on the slide, you can also ask for running accounts and profits for the person to produce his accounts, the defendant to produce his accounts, show you exactly how many money he has made out of use of your intellectual property. And all those monies, profits, etc., have to be returned to you if there is a decree in your favor, right? And the last item on our list is a declaration. So you can get declarations in the decree in your favor, saying you are the actual owner of the intellectual property, or that the threat that is being made is groundless, or that that the trademark is invalid or the patent is invalid. So these reliefs should be specifically asked for a declaration to be made to that effect, right? So these are all the reliefs available to you in an intellectual property dispute. Now we've come to the last leg, which is basically, now once a plaint is filed, I'm going to talk about the litigation from the perspective of the defendant. What does the defendant do? So first is, like I said, there are 4 things you have to do perfectly, right, while filing a suit. The same things have to be examined from the side of the defendant to see if the plaintiff has done correctly, because these preliminary objections, if made correctly, will ensure that the suit goes away, that it gets dismissed, right? So you have to show that there is no cause of action against you, or there is no cause of action disclosed against you in the plaint, or there is no jurisdiction, or that the suit is barred by limitation, or that there are issues of valuation and court fees is not paid correctly, or there is a bar in law from instituting the suit itself. Now, an example of bar in law would be, for instance, that a suit for infringement of trademark can only be brought by a registered proprietor of the trademark. So if a person without any registration in his favor, so let's say I'm A, I have registration for trademark in class 1 and class 2. So but I bring a trademark infringement suit to court for infringement of my trademark in classes 1, 2, and 35. Right? But admittedly, I don't have a registration in class 35. So in respect of class 35, a suit for infringement is not maintainable at all. So that is a bar in law. So I'm doing something indirectly, which is barred by law, that I cannot be doing. So this becomes one of the defenses that you can take as a defendant to such a suit. Now, defenses have to also cover merits, right? The merits of the matter. So in the case of a patent, the defenses that are available to a person who is alleged to have committed infringement are basically any grounds that are available to a person if he was seeking for revocation of the patent, right? So you can see section 64 on the screen. So revocation of a patent can be revoked on the following grounds. So the same grounds are also available if you want to raise issues of invalidity in a lawsuit that has been brought against you in respect of that patent. Right. So the first ground is that the invention, so far as claimed in any claim, was claimed in a valid claim of earlier priority. So basically, a claim already has earlier priority in comparison to the patent on the basis of which the suit is filed. That the patent was granted on application of a person not entitled to apply for a patent at all, or that the patent was obtained wrongfully, right? Or the patent as claimed in the specification is not an invention, which means it is hit by the Nunn's test, which you will all be familiar with by now. And that it is not novel, and that it is not useful, or it is not non-obvious, right? Or it is prevented by false suggestion or representation. So there are several grounds like this. Go through section 64 at your leisure. I'm sure this was also covered in your patents classes otherwise as well. So basically, any ground available for revocation becomes a defense for you in an infringement suit. Other than that, there are some conditions that can be imposed under section 47 if the patent is not being used as per the conditions laid down in section 47. Also, it becomes a ground for revocation. So just quickly to cover these, the grant of a patent under this act shall be subject to the condition that any machine apparatus or other article in respect of which the patent is granted, or any article made by using a process in respect of which the patent is granted, may be imported or made by or on behalf of the government for the purpose merely of its own use, for the government's own use, right? Or a process which is meant for the government's own use. So these are examples of conditions that can be imposed on your patent registration. So a granted patent is always subject to these conditions. So as long as you're not fulfilling these conditions, a suit brought in respect of a patent that falls foul of any of these conditions would then give rise to grounds for a defense or a counterclaim in a suit for infringement as well, right? So similarly, in a copyright on merits, you would raise grounds of fair use or fair dealing. We've already covered fair use and fair dealing in quite detail in our copyright class in the first few sessions that we had done. So in a copyright claim, essentially, you can say four things. One is that the copyright that you're claiming is not copyrightable at all because it covers an idea and not the mere expression of the idea, right? Second, independent creation. If I'm able to show through evidence that there is no way I could have known about your copyrightable work and I created mine on my own without the involvement of yours, then I can claim the defense of independent creation. Third, I can always say that it doesn't amount to copyright infringement because my work is not substantially similar to yours as required under Section 51 of the Copyright Act. Or four, I can say that it's covered under the myriad of exceptions that are available under Section 52 of the Copyright Act, which in India we call fair dealing. Right, we've already covered the Rameshwaram photocopy case where we said that photocopying of works, copyrightable works for the purpose of instruction or teaching will not amount to copyright infringement because it falls under the exception of fair dealing. So on merits, these are the defenses that are available to you in a suit for copyright infringement. In a trademark infringement suit, of course, this is not an exhaustive list of all the defenses available. So in addition to these preliminary grounds, these additional grounds are available. One is that my mark is not similar to yours at all. Two, that I was an honest concurrent and adopter of the mark under Section 12. Or three, that I started using the mark prior to you. So you don't have any separate rights available to yourself. And four, that your mark comprises a generic word. For example, matrimony, right? Matrimony is used by Bharat Matrimony. It's used by 100 other brands as well. So I can't claim individual rights over the word matrimony because it is a generic word, being a word that basically describes the good or the product itself, right? So because it's a generic word, I cannot have exclusive rights over it. Therefore, if your trademark comprises only of a generic word, I can use that as a defense to say that my mark is not actually infringing yours because you have a claim over something over which you cannot have an exclusive claim at all. So now we've come to the last aspect of intellectual property litigation that I wanted to address. So under the Evidence Act, you can lead what we call expert evidence, right? So you can call an expert witness in the witness box to prove your claim. And in intellectual property, an expert is required for various reasons. So For example, let's say there are two chemical patents and we have to compare to see if the process of making one drug, not the process, but if one drug combination is in violation or an infringement of a patented drug combination. So, to ascertain this, a judge in a normal court in India will not have the requisite scientific and technical expertise, right? So, what parties can do is they can call for an expert witness to come and aid them in the process of explaining to the court and establishing infringement, right? So what happens normally in court is the plaintiff will call his expert and file that expert's report. The defendant will call their expert and file that expert's report. So what the judge is able to do in that case is compare the reports of both the experts to see if there is any finding of infringement or non-infringement that he can make. Now, there are a lot of situations in which these reports become self-serving because they are filed by parties, experts who are commissioned by the parties themselves, right? So in that case, the court even has the power to call for a third party expert and ask whatever doubts the court has in order to come to a conclusion of whether there is infringement or not. So unlike in other cases, several other cases of civil injury in India, in intellectual property disputes, expert evidence becomes very important. But that said, other jurisdictions are eons ahead of us in leading expert evidence, and India is still sort of growing in that area, and we're still trying to figure out a way to make our judges understand how expert evidence works and how expert evidence has to be led and how expert testimony has to be read and incorporated into our judgments and decrees. So that said, that brings me to the end of the topic on IP litigation and remedies. I hope you all found this helpful. I'm going to end here. Thank you so much for attending.